Para for dictation, exercise number 2, 5 seconds to start. 5, 4, 3, 2, 1. Having heard learned counsel for the petitioner and respondent bank, and having gone through the record, I find that the petitioner has, from the first stage of filing of the petition, sought to criticize the process of law. Full point. Even filing the earlier petition being special civil application, though the punishment order was already passed by the respondent bank, concealing that disciplinary proceeding is not concluded and the order as referred above came to be passed ex parte. Full point. The said order is a concluded issue and that point is left there. Full point. However, it is clear from the tenor of the said order that the petitioner was to be treated in service until the order passed by the bank is served upon him, and it is contended even in the year 2012 that the said order was not served upon the petitioner. Considering the totality, I find that the said order was already served or deemed to have been served on the petitioner at the relevant time, so far as the contention that the petitioner ought to have been continued on his earlier post. I find that the petitioner was selected for the post from which he is terminated, since those posts were not available at the relevant time, with the clear understanding and undertaking the petitioner and similarly situated persons were appointed on the lower post, wide order reference to which is made in the appointment order. The petitioner had applied for the post from which he is terminated. He was selected for the said post and was appointed on the said post. The respondent challenged the aforesaid communication in writ petition and prayed that the appellant be directed to release the pensionary benefits with effect from 2001, along with interest at the rate of 24% per annum, or in the alternative pay him pension under the new pension scheme. He pleaded that the decision of the appellant to insist upon the refund of gratuity as a condition for payment of pensionary benefits is ultra vires the provisions of the 1972 Act and articles of the Constitution. Full point. The present petition before the court forms part of a batch of writ petitions in which The central issue relates to the jurisdiction of the school tribunal constituted under the Act to entertain appeals in respect of grievances of primary school teachers as a result of the enactment of the Right to Education Act. Stop.